There was one bankruptcy case on the Supreme Court's calendar for this term, and it was argued on Monday of this week. The case deals with the constitutionality of the increase in fees paid to the U.S. trustee system beginning in early 2018. There was a constitutional challenge raised in many quarters to that increase because the fees were not immediately effective in the two states that have bankruptcy administrators rather than U.S. trustees. And by the way, the increase was not trivial. It was as much as 7 times larger than the fees being paid in the two states with bankruptcy administrators. The circuit courts of appeal were split 2-2, and so therefore the Supreme Court granted certiorari in January of this year to resolve the circuit split. As usual, it's impossible to guess from oral argument how the court will rule. But based, among other things, on questions by the Chief Justice, I am led to believe that the Supreme Court is going to find that the increase was unconstitutional. As background, of course, the court has previously held, as the government argued, that procedural aspects of bankruptcy law do not require uniformity under the bankruptcy clause of the U.S. Constitution. It's only substantive bankruptcy rules that must be uniform, and so the government said the user fees, as they called it, were perfectly constitutional because they were only procedural. The Chief Justice took a very pragmatic approach to that question when he said that if you're a bankrupt or distressed company in Chapter 11, cash is everything. And with such a large increase, he said, it would, among other things, influence where a debtor decided to file into Chapter 11. The court also spent, I'd guess, more than half of its time talking about remedy. Now, it seems to me that the justices would not have been worrying much about remedy if they were predisposed to find that there was no constitutional impairment. The remedy issue, I think, to me, is going to come down in favor of giving refunds to those who have outstanding challenges to the fee increase. And, by the way, there is a class action that is currently pending on appeal right now in the Federal Circuit that might be able to give refunds to all Chapter 11 debtors if the Supreme Court decides that the differing fees were unconstitutional. The case, as I said, was argued on in April, and of course there will be a decision by the end of the Supreme Court's term near the end of June. I suspect the decision will probably come down maybe around mid-June, if not earlier, because in late June the justices are going to be handing up their decisions on the really hot topics like abortion. I am Bill Rochelle, Editor-at-Large for American Bankruptcy Institute. I will return same time next week with something interesting in the world of bankruptcy. Until then, be well, stay safe, and